number 23-10559. This is the time set for a status conference with respect to this matter. I'll hear from debtors' counsel.
Thank you, Your Honor. This is Howard Cohen, Fox Rothschild counsel for the debtors. Your Honor, we are pleased to announce a resolution of the matters that were scheduled to be heard today, as well as a settlement with the committee. Your Honor, if it's acceptable, I will turn over the virtual podium to my co-counsel, Ms. Jones at Kirkland & Ellis, to provide the court with an update regarding the settlement and confirmation matters.
Yes, thank you, Mr. Cohen. Ms. Jones?
Good afternoon, Your Honor. Elizabeth Jones of Kirkland & Ellis on behalf of the debtors.
Good afternoon.
Your Honor, first and foremost, we'd like to thank you and your staff for accommodating us this afternoon and for all of your patience with us as we've moved through these cases. As Mr. Cohen said, we are very pleased to be here to provide a status update that we've reached a global settlement that resolves pending litigation over the debtors' motion to disband the committee and the committee's motion to reconsider the scheduling order. We expect that this will result in a near full consensual confirmation hearing of an amended plan next week. Over the last 2 weeks, the debtors, the committee, and the crossover group have been working very hard to find a mutually beneficial path forward in these cases, all of which culminated in the parties reaching agreement in principle yesterday. The parties are now in the process of documenting the agreement in an amended plan, but we thought that it may be helpful to provide the court and all parties in interest with a brief overview on the record of the key terms of the settlement, if that's acceptable to Your Honor.
Yes, please. Thank you.
Thank you. Your Honor, there are 6 key points to the settlement. The first being that holders of Class 6 convertible notes claims will now receive an allocation of new warrants to purchase up to 1.25% pre-dilution of the new common stock, all on the same terms as the new warrants were proposed to be issued to the holders of Class 4 second lien term loan claims. Second, the fees and professional costs of the indentured trustee will be paid pursuant to the plan. Third, the committee agrees moving forward to limit its role through confirmation to working in good faith with the debtors' professionals to confirm that there are no unencumbered assets at Lannett Company, Inc., the holdco, that would otherwise materially change the proposed value recovery to the holders of convertible notes, to ensuring confirmation of the plan and its compliance with the terms of the settlement that we've all reached, and to filing and prosecuting the retention and fee applications of the committee professionals. Your Honor, the next point with respect to the settlement is that the plan will include additional language to further clarify that holders of general unsecured claims will remain unimpaired through these Chapter 11 cases. Fifth, the committee, its members, and the indentured trustee under the convertible notes will receive the appropriate releases and exculpation to the extent applicable under the plan. And 6, the motion to disband and the motion to reconsider the scheduling order, including all related discovery requests, will be adjourned and dismissed with prejudice in connection with confirmation and upon the effective date of the plan. Your Honor, with respect to these terms, we've also shared them with the U.S. trustee and have been working very closely with their office over the past 48 hours to address their questions both on the settlement and the plan. We're very grateful to their time and efforts and for working with us to move these cases forward. We are very encouraged by our conversations with them, and we are cautiously optimistic that by the time we're in front of you next week, there will be very few, if any, open issues to address. So, Your Honor, with respect to next steps, the parties are working on an amended plan and proposed confirmation order that will incorporate the terms of the settlement agreement. The debtors will file both of those documents along with the confirmation brief on Monday to provide all parties with sufficient notice to review in advance of the June 8th hearing. In addition, Your Honor, the debtors intend to share a copy of that amended plan with the U.S. trustee in advance of filing, and will continue to work with the U.S. trustee in their office once it's filed to the extent necessary to resolve any remaining open issues. So unless Your Honor has any other questions or would like to hear from the other parties, that's all from us. And the debtors would like to reiterate very much their appreciation to you and your chambers, the U.S. trustee, the committee, and the crossover group for getting us here. And we very much look forward to seeing you next week at confirmation.
Thank you. I do appreciate the update. This is very helpful. And I congratulate the parties on working together to reach a global settlement. I'm sure that it was a lot of active discussion So congratulations. One, um, one issue I have is the hearing that's scheduled for June 8th. Do you have a sense of the amount of time that would be required, the number of witnesses? And the reason I ask is because my calendar has opened up in the morning, and I was wondering if the parties would like to move that hearing until 11 instead of having it in the afternoon.
Your Honor, that's acceptable to the debtors. I'll defer to the rest of the parties if that works. But yes, that's acceptable to the debtors.
Would anyone else like to comment on the hearing time and changing it from 2:30 to 11 on the 8th?
Your Honor, Artesian on behalf of the U.S. trustee. Your Honor, I just want to ask my colleague Joe Cudia if he's available at 11 because I have a hearing in another case at that time.
Yes, Your Honor, Joseph Cudia for the United States trustee. I was just about to comment that I have a 10:30 hearing that day, so no, that time would not work for me.
Okay, all right. So would it be helpful to move it up? I'm a little concerned that 2:30 may be not enough time. Would it help if we moved it to like 1?
Your Honor, we don't expect the hearing to take more than an hour. We do think we've been working with other parties as well on confirmation order where one works for us, but we do think that there will be very, very few, if any, open issues to address on that date.
Then we can leave it at 2:30. That's fine with me. I just wanted to make sure that there was ample time, and I usually try not to schedule confirmation later in the afternoon so that parties have sufficient time. But if you think that, I see that there's only a few objections filed at this point, but if you think 2:30 is fine, I will just keep it at that time. Okay.
Yeah, thank you, Your Honor.
Okay, that probably makes it easier. Does anyone else wish to be heard?
Your Honor, Todd Myers, Kilpatrick Townsend for the committee. If I could just speak very briefly. Thank you, Your Honor. Your Honor, yes, it's been a very hectic 2 weeks since the committee was appointed and hired professionals. We've been dealing, as you know, with motions to disband, motions to redo the timeline, discovery. We also have been preparing objections to the plan and cash collateral, which were otherwise due, I think, on yesterday. So there's been quite a bit of work. Fortunately, a few days ago, the door was opened for some discussions with the debtors and the lenders on the one hand and the committee on the other, who obviously have had very divergent views as to how this case should proceed. We began discussions, and that led to the deal that Ms. Jones outlined. So we are pleased with the deal. Under the circumstances and given the debtor's particular capital structure, we thought this was the best deal available without risking, various things that could happen if we litigated and were unsuccessful. So we do think that each of the terms are appropriate and hopefully will ultimately be approved. We did, as Ms. Jones noted, the debtor did agree that the committee can do some quick due diligence with respect to the holding company. Just to explain that a little, Your Honor, obviously at the operating company level, that's where we believe all of the trade creditors are, and they're getting paid 100 cents. So, whether or not the lenders have valid liens doesn't really matter. It can't really do better than 100 cents. But at the holdco level, where the convertible notes are not being obviously paid in full, and are only getting warrants, we do want to make sure that I think it's over $500 million in debt that is secured in this case and is owed at the holding company level together with the convertible notes is subject to valid liens, or if not, that the assets are of immaterial value, such that there's no better or materially better recovery that the convertible notes should be receiving. So we are going to do that due diligence. We think with the debtor's cooperation and the lender's cooperation, that will only take the weekend, and so hopefully we should be able to check that box very quickly. So with that, Your Honor, we're very satisfied with the result under the circumstances of the case.
Okay, thank you, Mr. Myers.
Thank you, Your Honor.
Anyone?
Your Honor, may I be heard briefly as well?
Yes.
Thank you. Benjamin Beller from Sullivan and Cromwell on behalf of the Crossover Group. I just also want to voice our appreciation for the parties' efforts to keep this case on the timeline that debtors and our group negotiated and entered Chapter 11 on the basis of. We're glad also that we've struck a resolution that keeps the professional fees down through confirmation, which, as you've seen from some of the briefing that has already been filed, is hugely important to the company on a go-forward basis and to all of the stakeholders. So we look forward to moving forward to confirmation next week and to emergence shortly thereafter.
Okay, thank you, Mr. Bell. Anyone else? Okay, well, I very much appreciate the status report. We'll look forward to receiving the amended plan on Monday and seeing you only June 8th for your hearing. I hope you all have a good weekend, and thanks again. We stand adjourned.